It's the appointed time and we have a quorum. Welcome to the meeting of the Bills Committee on Electronic Traffic Enforcement Miscellaneous Amendment Bills 2023. I call to order the meeting. Let's invite the government officials to enter first. Welcome, government officials. If I may draw members' attention to the list of follow-up actions arising from the discussion at the meeting on 26th of March 2024, that is LC paper number CB-4464/2024-01, and the administration's response to the issues raised at the meeting on the 26th of March 2024. They have been set out on the agenda. Do members have any comments regarding the administration's response? If not, well, does the administration have anything to add? If not, then we will skip this part. Let's proceed to the clause-by-clause scrutiny. We were at page 31 of the marked-up copy. Ms. Chang, please. Thank you, Chairman. We can start from clause 23 of the bill. That is page C3949 of the blue bill. The clause 23 is to amend regulation 4. We propose to repeal 15 and substitute it with 15 AAF in regulation 4, which sets out that the certificate of service must be used in accordance with Form 3 in Schedule 1. As for the specified form of Form 4 and Form 5 will be amended as well. So you're just changing the numbering, correct? Yes. Any questions? If not, please proceed. Clause 24 is to amend Regulation 5. We propose to amend the English text and amend Schedule to Schedule 1. Any questions? If not, please proceed. Clause 25, that is page 34 of the marked-up copy. We are to repeal Schedule and substitute it with Schedule 1. And we will repeal Form 1 and 2. We propose to amend the numberings and the wordings of the schedule and to accord the form with a number. As for Form 5, that is the registered address and name of the drivers, we propose to add e-contact means to it, and we will change some of the wordings as well. Are we at 001? Well, we're at page 34 to 35 of the marked-up copy. Please read the content. Ms. Chang, please proceed. Any questions with the forms and the wordings? Any questions? Any comment? If not, please proceed. Clause 26. That is page C3962 of the blue bill. We propose to add Schedule 2 after Schedule 1. There are fixed penalty notice, electronic fixed penalty notices, and the demand notice, and we set out the information and particulars that have to be included in the notice. For fixed penalty notice, the notice number, the registration mark of the motor vehicle concerned, the statutory provision contravened, the time and date of the contravention along with the location, the code number representing the contravention have to be stated on the fixed penalty notice. Also, the amount of the penalty, e-payment number and bill type, the payment method, the period for making the payment, the consequence for failing to make the payment within the period or to dispute liability for the alleged contravention, method of inquiry, the police numbers of the person authorized to issue the fixed penalty notice. If the person is a traffic warden, the number of the identity card issued to the person and the date of the fixed penalty notice have to be set out on the fixed penalty notice. Any questions regarding the content and particulars on the fixed penalty notice? Any questions? Mr. Lai? Thank you. I would like to ask about the method of inquiry. What methods will you provide for the contraveners to lodge inquiries? Mr. Chan, Chief Superintendent of Police Traffic, please. Thank you, Chairman. Mr. Chan, please. Thank you, Chairman. The method of inquiry includes telephone inquiry and online inquiry. What do you mean by online inquiry? Do you mean I am smart? Or do you mean that people have to log on to your mobile application? We mean our website. Chairman, in other words, it means that you will be including the website on the fixed penalty notice, and the people will have to go on to your website and enter their inquiry, and then you will give them a reply in a reasonable time. Is that correct? Yes. Can they write to you? Yes. So you will include the telephone number, website, and your address for people to lodge inquiry. Is that right? Ms. Chang, can you let us know where the method of inquiry is on the form? It's at page 58 of the marked up copy. Sorry, page 57. Item 5. Or the page 56 of the English version. The police will announce the details for the method of inquiry in due course. So it's not available yet. If you allow people to write to you, then you will set out the address. Is that right? Yes. Any other questions? If not, let's proceed. Part 2, electronic fixed penalty notice. The information that have to be contained thereon include the notice number, the date of the electronic fixed penalty notice, the registration mark of the motor vehicle concerned, the time, date, and location of the contravention, the code number representing the contravention, the amount of the penalty, the e-payment number and bill type, the period for making the payment, as well as the ways to gain access to an information system designated by the Commissioner of Police through which the corresponding fixed penalty notice may be inspected, and the payment method, the consequence for failing to make the payment or to dispute liability for the alleged contravention, an explanation of the code number used to represent the contravention, other matters relating to the contravention or fixed penalty, and the method of inquiry. Any questions? Mr. Lai? You will specify the ways to gain access to an information system designated by the Commissioner of Police. So will you embed a hyperlink to the fixed penalty notice? No, there will not be a hyperlink.
'Cause 我哋係
No, there will not be a hyperlink.
我哋係
Hyperlink.
我哋係
Hyperlink. If this is the case, then if the person wants to check the content of the fixed penalty notice, do they have to log on to your mobile application? That is correct. They will have to either go on to the police's website or log on to the mobile application. Can they access the information via IM Smart? Yes. Have you decided that you will include the content of the fixed penalty notice on the IM Smart? We're talking to the relevant party. I think that people feel more comfortable using IM Smart. I understand why you don't include the hyperlink in the fixed penalty notice messages, but it's actually very inconvenient for people. More and more people are using IM Smart for different purposes. If you include the content of the fixed penalty notice on the mobile application, it will be more convenient. But we have to pay attention to the speed. It's very slow for people to access other websites via IM Smart. Many people find it very slow when they want to access other government websites via IM Smart. Let's go into it when we come to it. Thank you. Next. Part 3, demand notice and the content that have to be included therein, including the notice number, the name, the number of person's identity document of the person to whom the demand notice is addressed, the registration mark of the motor vehicle concerned, and the statutory revision contravened, the description of the contravention, the time, date, and location of the contravention, and the requirements that the person must pay the fixed penalty notice or notify the commissioner of police that the person wishes to dispute liability for the alleged contravention, and the amount of the penalty, the e-payment number and bill type, the payment method, the period for making the payment, the consequence for failing to make the payment within the period. Also, the information relating to the notice to dispute liability for the alleged contravention, including how to send the notice, the period for giving the notice, the consequence for failing to give the notice within a period, the method of inquiry, the name and police number of the police officer authorized to issue the demand notice, and the date of the demand notice. Any questions? Mr. Lai Tong-kwok. Thank you, Chairman. Under paragraph 4B, it says a description of the contravention. But then in the parts about electronic fixed penalty notice and fixed penalty notice, you do not include a description of the contravention. So why is there such a difference? Why do you only provide a description of the contravention in the demand notice? The police, please. Mr. Chan Xiuming, Chief Superintendent of Police, please. Because of the text limit of the SMS, we will not be including the description of the contravention in the SMS. But when people check the details on the website, they can get hold of such an information. Understood. Please proceed. Part 4, electronic demand notice and its content. It has to include 1, the notice number, 2, the date of the electronic demand notice, 3, the registration mark of the motor vehicle concerned, 4, the information relating to the alleged contravention, including the time, date, location, the code number representing the contravention, 5, the amount of the penalty, the e-payment number and bill type, and the period for making the payment. 6, the period for the dispute of liability for the alleged contravention. 7, how to gain access to an information system designated by the Commissioner of Police through which the corresponding demand notice may be inspected, and the payment method, the consequence for failing to make the payment or to dispute liability for the alleged contravention, an explanation of the code number used to represent the contravention, other matters relating to the contravention, penalty, or dispute of liability.
Any questions? Please carry on. Mr. Lai Chong Kwok, Chairman, please told us that for the electronic SMS, the messages would be limited, but for the paper version, you would include more details. And indeed, in the e-version, you do carry a lot of information. So how are you going to be serving the electronic demand note? Is it going to be a PDF, or is it going to be by way of SMS? Yes, SMS, or what? Any difference there, please? Mr. Nick Nip, Superintendent. Do you want the question repeated? Mr. Lai, please. Now, for the electronic demand note, do you serve via SMS, or are you going to be attaching a PDF in the SMS? Now, with an SMS, indeed, you don't include too much details there. But in part 4, there is so much that you include there. If you present everything in the text of the SMS, I'm sure there will be problems. So how can you serve this electronic demand notice? Yes, how do you go about doing it? Chairman, thank you. Thanks very much, Mr. Lai, for the question. In fact, the design of our system is such that we would be issuing the SMS in text. If we include additional information like an attachment of PDF, then we would have certain format requirement. We would make sure that even older phones would be able to receive the SMS, so we would serve this by way of SMS. Chairman, there are two ways the motorists can receive the information, either email or by phone. Now, when you issue the tickets, would there be any difference between the two formats? The SMS, you are limited by certain restrictions, but there is no restrictions regarding email. So are you going to be using the same format in email as you would in the SMS? Mr. Chen? Well, they are consistent in order to avoid any confusion on the part of the recipient. There is no limit with regard to emails, but in order to avoid any misunderstanding, we will make the two contents consistent. Mr. Chen, yes, I'd like to follow up on Mr. Lai's question. I fully appreciate what the administration said. That by way of clarification, SMS indeed, you are limited by the number of words, so therefore you would include the salient information. But when you look at the electronic demand note, there is a whole host of information there. There are lots of details there. I'm not sure whether you have worked this out with the telecommunication operators. Are you going to be including all these details in the SMS? They may cut short some of the information because of the limitation. Do you have any template about these electronic notices? Mr. Nick Nip. Chairman, if I may, in Part 4, electronic demand notice, this is the notice posted on the website, so this will not be limited by the number of words as it would in SMS. So there might be a bit of misunderstanding there. So Part 4 is actually for the website. What about the email notification? SMS, you will not adopt the e-demand notice content, would you? No, they said they would be the same. Would they be the same or would they not be the same? Can you be more specific, please? Now, we heard that for SMS, indeed, it is limited by the number of words, and you can only include relevant details. But for website and emails, you can include more information. Now, you said that they are consistent. How can you deal with this comprehensive range of information? Mr. Chen, Chief Superintendent. Now, for SMS and emails, the contents are the same. Now, for electronic demand note, they're posted on the website and they are in sufficient detail, so they do differ. Mr. Mack? Yes. Thank you very much for the questions. If I may explain a little bit here, if members refer to 0057, Part 2, electronic fixed penalty notice, that's page 56 in the English version. Now we are comparing this with 0060 with the electronic demand notice, that's page 59 in the English version. These are two different procedures and I stand to be corrected. First, for electronic fixed penalty notice to be issued, there will be e-fixed penalty notice to be issued first. This will be issued by way of either email or SMS. Now, the content for these two means will be the same and they will be short. Now, the details there would be enough for people to make the payment if the driver or the owner would like to have detailed information, like the details that are included in the paper version. They will have to log on to the police website to view the electronic demand notice in Part 4. Now, Mr. Lai referred to this a moment ago. This includes more information. So it is not appropriate for all these to be included in the SMS or the email, but in Part 4, people can have access to all the detailed information there. Chairman, now we are dealing with the implementation details, and we are looking at the forms and the provisions. It would be hard for us to grasp the details. If you have the template, if you have the format, you might wish to show us later on, maybe at the next meeting, so that people who contravene certain provisions would know what they are letting themselves in for, what form that they will be receiving. That would be helpful. Yes, we said that we would like to have a look for a site visit. I know that they are making arrangements. There are some loose ends to be tied up. We will make an arrangement, maybe next month or the month after next. Doesn't matter whether the bill has been passed or not. We will certainly take a look on site so that we would know in greater detail about the arrangement. Work is in hand. Mr. Lai, Chairman, I've got a suggestion here. With the implementation of this scheme, you should mount publicity. Now, people will receive the SMS. The details are brief. And if I want to look at the fine details, I have to log on to the web. There are so many procedures there. People might not be tech savvy enough to understand everything. So when you launch this particular scheme, I hope that you would mount comprehensive publicity so that people know where they stand. And you should tell people whether you're going to have the hyperlink and so on. And you should take the opportunity to warn people of scams. In particular, when they see the hyperlinks, you still have the luxury of time. You should model for this easily. What we are interested in would be the format, the template. We understand that the way the law is couched is in relation to the implementation, and there will be some changes to the system. But overriding objective is to make sure that when people receive the tickets, they know where they stand. If they want to find out more about the details, they should be able to have access to the details in an easy way. And I hope you would consider the publicity efforts. Mr. Chen, thanks very much, Mr. Lai, for the recommendations. In fact, prior to the implementation of the details, we have already arranged for a publicity. These will be fully launched prior to the implementation of this ordinance. As to the format, the app by June or by end of June, we should be able to have a demo for members. Right, later on, we can revisit the formats and the templates, Chairman. For a vehicle or for a driver, if they contravene the law, there will be electronic serving of the notice in place of the paper version. Now, what we are talking about now is the inclusion of the details in the e-version. But it seems to me that they have to make sure that the violator of the law will be in a position to know about the contravention. There will be the e-versions there. But have we? Do we have more information about the details there? Well, remember, we are dealing with the details of the demand notice, and they are included in the bill. And under the law, there is no mention of the format. But previously, when we discussed the bill, the police said that a letter would be sent to the person liable. Please, any response there, please? Mr. Chen, thank you for the question. At the beginning of the implementation, there will be a dual approach of using the paper version as well as the e-version to make sure that the person liable will receive the ticket. We will ascertain the length of time when people are accustomed to this electronic system. We will be doing away with the paper version.
Because just now Mr. Leung asked about the format of the notice. Chairman, perhaps I can supplement. Yes, Ms. Cheng. About the content of the fixed penalty notice and electronic fixed penalty notice, the particulars that have to be included are already set out in the bill. But as for the details, and the format that will be designated by the Commissioner of the Police so that there could be a greater flexibility. Now we only include the particulars that have to be included in the bill. Any questions? If not, please proceed. Now we move on to part 4. Which page? Page 61 of the marked up copy and C3975 of the blue bill. We amend Fixed Penalty Criminal Proceedings Ordinance Cap 240. Clause 27. We propose to amend Section 2, the definition of the police, and we repeal 香港輔助警察隊的成員. Mr. Lai? In the original provisions, you used the word 成員, as in members, but now you substitute it with 隊員, which means team member. What is the difference? Legal advisor or the representative from the DOJ, Mr. Lai, or Mr. Anderson Chan? Mr. Anderson Chan. Thank you, Chairman, and thank you, Mr. Lai, for the question. When we conduct adaptation exercise, we've made reference to other legislations in Hong Kong, including the Chinese version of the Auxiliary Police Force. Under Auxiliary Police Force Ordinance of the laws of Hong Kong, they use the word 隊員 as in team member instead of 成員, member. And that is why we adapt to the law here as well. We think that the meaning is the same. We are just aligning the text across the legislations and laws in Hong Kong. Any comment? If not, please proceed. We propose to add 8 new definitions under Section 2, Bracket 1, including demand notice, e-contact means, electronic record, ETO, fixed penalty notice, information system, prescribed information, and registered e-contact means. By adding these declarations or definitions, we want to clarify the meanings of the words under the section. Any questions? If not, please move on. We propose to add subclause 3 after Section 2, Bracket 2. The reference to sending an electronic fixed penalty notice or electronic demand notice in the form of an electronic record through a registered e-contact mean is to be construed as A, if the registered e-contact mean is an electronic mail address, or if the electronic e-contact means is a telephone number. Understood? Mr. Lai? Chairman, I remember that we've discussed this before, but I want to clarify. One of the e-contact means is electronic mails. Some of the email service providers would automatically put the emails that they think are junk into the junk mailbox. How do you make sure that the e-notice will not go to the junk mailbox? That is, the email sent by the government will not be filtered out. Mr. Fong, please. Mr. Frankie Fong. Thank you, Chairman. The email address that the government use include the domain name of gov.hk. For email sent by an official website, we know that service providers would not be filtering them out or screening them out. Chairman, this is their understanding and that's my understanding as well, but nothing can be certain. This electronic fixed penalty notice is a very important piece of notice because as long as an email has been sent, an SMS will not be sent. For email service providers or internet service providers, can the administration inform them of the regime or send them a letters reminding them that they should not filter out or screen out the government's emails? Can this be achieved, Mr. Fong? We will have to look into that. Because we cannot control the email systems that the users may use, we will have to look into that to see if it's technically feasible. Mr. Lai Tong-kwok, I think that is technically feasible. You know what email systems Hong Kong people are using. You just have to send them a letter. Of course, you cannot cover all the service providers. I'm well aware of that. After establishing a database of the email address of the drivers or vehicle owners, you would know what email service providers people are using. You just have to send them a letter. I don't think that you have to conduct any further study into it. There are some members who are in the IT field who would like to supplement. Please. Chairman, I think that this is a very important point. Some emails may not be filtered out, but sometimes the capacity of the email servers of people may be fully used. So does the administration have any plan to use alternative means to make sure that the contraveners actually receive the notice to avoid any cases of appeal? Well, even if we send a letter to the designated person, it may not be received. The same goes for fixed penalty notice. It may be delivered to the wrong mailbox. Just now, the member asked how we can make sure that this will not happen. Mr. Fong, do you have anything else to add? I think that Mr. Lai's suggestion should be followed up on, because we will receive email address of the people and we will know what service providers they use. When necessary, we will reach out to those service providers to see if they filter our emails out by mistake. We can do that definitely. Will you remind the members of the public that they should make sure that their server will not be fully used? Well, apart from talking to the telecommunications companies, we will step up publicity and education, and we will remind the people about the management of their mailbox. We ask them to not overload their mailbox. Next, Mr. Tony Che. Thank you, Chairman. I would like to ask about the definitions. That is the definition of police officers. In page 5 of the marked up copy, the definition of police officer or includes traffic warden. Can you explain the difference? They could be police officers handling different things. That is why traffic wardens is not be included in the definition here. I think that you're talking about the adaptation. Is that correct, Mr. Chen? Thank you for your question. For this piece of legislation, traffic warden can only handle problems with parking, but for Cap 570, only police officers can handle such kind of cases. For offenses of moving vehicles, traffic wardens cannot handle those cases. For illegal parking, traffic wardens can issue fixed penalty notice, but for moving vehicle offenses, only auxiliary police or regular police officers can handle those cases. So to a certain extent, traffic warden can only issue fixed penalty notice. They can only issue fixed penalty notice for people who have not top up their meters. So traffic wardens' duties are quite limited. So there is a division of duties in terms of law enforcement between police officers and traffic warden. When we have so many smart meters, what else can the traffic warden do? Can you explain about it further? Chairman, perhaps I have gone beyond the scope of the bill. Well, traffic wardens are equally important. Mr. Chan, please. Traffic warden can only enforce Cap 273, but for 240 or Cap 240, only regular police officers or auxiliary police officers can enforce. For the second question, most of the traffic wardens conduct foot patrol. For moving vehicle offenses, they may not be able to follow up on those immediately. That is why it's more appropriate for us to have regular or auxiliary police officers to handle those cases. Next, Mr. Dennis Lang. I would like to ask about page 64 of the marked up copy. It says that the e-contact means include SMS and emails. But SMS and emails are just notification. They do not contain the details of the notice. People will have to go onto the website of the police force in order to check out the details of the fixed penalty notice. But then in bracket A and bracket B, it says that the notice will be sent to the electronic mail address and telephone number, and as long as they are sent, the contravener would have been deemed to have received the notice. So does it mean that as soon as people receive the notification, it means that they have also received the fixed penalty notice or the electronic demand notice? Ms. Zhang? Thank you, Chairman. The electronic fixed penalty notice will include sufficient details informing the person that they have contravened the offense, and the content of the electronic fixed penalty notice will be set out in Schedule 2. Specific particulars include the registration mark, the location, and the date of the contraventions. With these information, the receiver of the SMS and email would know that they have contravened the offense.
呢一個都係一個
So this is also a statutory notice. So the amendment of this ordinance is meant to confer the same status on the electronic notice. Mr. Leung, any follow-up? Is it clear? Whether it is email or SMS, you contain brief information. So would that be enough for the person liable to know what contraventions and also the liabilities on his or her part? I think this has to be made clear. Now, for the information served electronically, would it be carrying the same weight as the information in the paper-based demand notice? I think we have to go back to the principle of the bill. But for the SMS and email, because of the limitation, they contain less information than the paper-based notice. But they would contain the registration mark, the date, time, and location of the contravention, so that the person liable would ascertain whether he or she has committed the contravention. But for the detailed information, one can log on to the police designated website for details. All right, please carry on. Oh, 65 C3967. We propose to do away with Section 3 and to include 3 and 3AA and to 3AF. We include the issuance of electronic demand notice. This is similar to 370. 123 will replace 312 of 240 regarding the legal basis of issuing the notice and also the serving of the notice. Now, for the notice, one has to issue the electronic version. Does it have to be 12 hours or can it be faster than 12 hours? If one receives the notice and would like to clarify, would 12 hours be too long, or can one conduct the checking immediately? Mr. Chen? Well, the 12 hours would be the longest time. Normally, one would receive the notice within a couple of minutes. Any questions? Please carry on. 3, 5, and 6 provides the fixed penalty notice that must be in specified form and contain prescribed information. We're going to be seeing this in Schedule 2 later on. Any questions? Please. 3AA replaces the existing 3, 3, 4, and 6. We include the electronic means of payment and the period of payment. The issuance, our legal advisor would like to jump in here. Section 29, there is also bracket 7 and 8. The administration hasn't quite explained this. Can you go back to section 28, bracket 7, 3, 7, and 8, please? Section or clause 28, 3, 7, and 8. If there is any inconsistency between the information in the fixed penalty notice and that in the corresponding electronic fixed penalty notice, then the fixed penalty notice prevails over the e-fixed penalty notice. This is consistent with what we said when we scrutinized 370. Thank you. 3AA, we've covered that, and that's the period for the issuance of the electronic notice. This is a rearrangement of the order. The details are the same. Any questions? Please. 3AAB replaces 3.5, bracket 5. The e-notice can be accessed by electronic means, and the demand notice and the electronic demand notice must, in a specified form and contain prescribed information. The details are set out in Schedule 2. Please. 3AAC replaces 3 bracket A. If someone has already paid the amount in full, then the person is not liable to be prosecuted or convicted for the scheduled offense specified. Any questions? Please. 3AAD allows the person liable to dispute liability electronically, and 3AAD4 provides that this electronic notice must be signed electronically, and a password assigned will have to be used to send this to this information system. If the information system accepts, it would mean that it would deem that the commissioner has already received the dispute. Any questions, please? 3AAE give definition regarding the digital signature in section 3AAD7. There is also the definition of the digital signature. Any questions? 3AAF reference 273. That's about the procedures regarding the certificate of service to be signed by for the commissioner is admissible. Mr. Lai? Digital signature, is it okay to use the I am Smart? Is it okay? Mr. Fong? I am Smart Plus, and there is the digital signature. This is okay to use. Please. 0073 C 3392. That's to amend 3A. In the light of section 27, we amend 3A1 to specify that the notices are the demand notice, and this is only a technical amendment. Any questions? Please. 0074, amendment to 3B. In the light of clause 27, there is a new interpretation when amending 3.1, and the notice here refers to the demand notice, and the wording has been fine-tuned. Questions? Some changes to the wordings? Please. 0076, amendment to section 4. Similarly, in the light of clause 27, regarding the demand notice, the new interpretation there, and here we have added notices and demand notices. We're amending 4123 regarding the notices or demand notices to make the provisions more readable, and some of the wordings have been altered. Any questions? Please. Page 0076, amendment to section 5, in the light of section 2728. Section 5 is amended, and some of the wordings have been improved, and this is only a technical amendment. Any questions? Please. Clause 34, page 78, amendment to section 7. In the light of clause 27, a new definition is included, and also a new provision added. We amend section 240, and we're amending similar amendments there regarding the printed version of the notice. Chairman. In these provisions, some of the Chinese wording 友誼 and preceding these, in some cases, you add 自己友誼, meaning you have the intention to. Mr. Chen. The 0073, 3A, for instance, in 3A1, we are breaking up the long sentence there. Now, if someone intends to dispute the liability, we are putting a comma to break up the long sentence, and we have to add 自己友誼 to make it sound, to make it flow better. In other cases, if there is no need for do so, we will not do so. Like 0074, 3B, 1A, we don't need to add such wording in that case in the Chinese version, unless it is absolutely necessary in the Chinese version to make it to make it flow smoothly. We would not be adding such wordings.
Mr. Dennis Leung. Okay. Let's move on. Clause 35, page 79 of the marked up copy. Section 8 substituted. We propose to repeal the section to renumber the provisions, and we will include the e-contact means. That is the contact means so specified by the specified person. Any questions? If not, please proceed. Clause 36, page 80 of the marked up copy, section 9 is amended. We propose to adapt to section 9 and amend the Chinese text of the Legislative Council and fine-tune some of the wordings. Any questions? If not, please move on. Clause 37, that is page 79 of the marked up copy. We propose to amend the cross-reference section and specify that the notice here means the demand notice and fine-tune some of the wordings. Thank you. Any questions? If not, please proceed. Clause 38 of the bill, page 80 of the marked up copy, section 10 amended. We propose to amend the cross-reference section and to specify that the notice here means the demand notice and fine-tune some of the wordings. So some wordings have been changed. Any questions? If not, please proceed. Clause 39, page 83 of the marked up copy, section 11 amended. We propose to renumber the section as 11 bracket 1 and fine-tune some of the wordings. And according to section 3A of Cap 240, the magistrate does not have the power to ask the contravener to pay penalty. So now we add the wordings or an additional penalty and the receipt for the payment to specify the power of the Secretary for Transport and Logistics. So the wordings of additional penalty is not mentioned in the existing legislation. Does that mean that we don't have additional penalty currently? Ms. Zhang? If the person liable does not pay penalty on time, then they will be subject to additional penalty. So where is this additional penalty written? Now, there is such a reference in other sections under Cap 240. Any other questions? Mr. Dennis Lang. Thank you, Chairman. Currently, if the person liable does not pay the penalty on time, then there will be additional penalty. So that the case will not have to go to the court. Even after the case has gone to the court, the magistrate or the judge may hand down additional penalty. Now here in this provision it says, or an additional penalty and the receipt for the payment. When a person is subject to additional penalty, it means that the person liable has not paid the original penalty. Shouldn't you use words such as or and to further clarify the provisions? Is there anything that is unclear here, Mr. Lai? Thank you, Chairman. Under this section, it says the Secretary for Transport and Logistics may make regulations specifying the person to whom and the places at which a fixed penalty may be paid. So if someone is liable to penalty, the Secretary can specify the person to whom and the place at which the penalty may be paid. That's all. Mr. Lai Tong-kwok. Just now, the administration mentioned time and again the word secretary. Do they mean commissioner of police? Here it says the Secretary for Transport and Logistics. Mr. Lai, can you please clarify? Thank you, Chairman. The power to make regulations lie with the Secretary for Transport and Logistics. Is that okay? Are we not scrutinizing the power of the Commissioner of Police? Page 85 of the marked up copy of the Chinese version. Is that okay? Please proceed. We propose to add section 11 bracket 2 to empower the Commissioner of Police to specify a form under section 11A bracket 1, the person to whom and the place at which a fixed penalty or additional penalty may be paid. Okay, any questions? If not, please proceed. Clause 40, page 84 of the marked up copy. A new section 11A will be added. We propose to add this 11A to empower the Commissioner of Police to, by notice published in the Gazette, specify the forms of the fixed penalty notice, a demand notice, electronic fixed penalty notice, and electronic demand notice. And the Gazette published, or the notice published in the Gazette will not be a subsidiary legislation. Any questions? The notice will not be a subsidiary legislation. Please proceed. We propose to add new section 11B to empower the Commissioner of Police to, by notice published in the Gazette, designate an information system for the, and the notice will not be a subsidiary legislation. Any questions? No, please proceed. We also propose to add a new section 11C to provide for transitional provisions for notices in prescribed forms issued before commencement date, including Form 1 and Form 2. And it specifies that the Form 1 and 2 will be enforced in accordance with the existing legislation, and it will expire on the expiry of 24 months after the commencement date. So if there is any dispute, should we rely on the existing legislation or the legislation to be enforced? The dispute will be handled in accordance with the existing legislation. Any questions? If not, please move on. Clause 41, page 86 of the marked up copy, section 12 amended. We propose to adapt to the Chinese text of Legislative Council. Okay, any questions? If not, please move on. Now we've come to part 5 of the bill. Amendments to Fixed Penalty Criminal Proceedings Regulations Cap 240 Subsidiary Legislation A. Clause 42, that is page 86 of the marked up copy. We propose to repeal Regulation 2. That is, the prescribed information must be set out in Part 1. Instead, the fixed penalty notice, electronic fixed penalty notice, should contain information as set out in Part 1 of Schedule 2 and Part 2 of Schedule 2 respectively. Clause 43, page 86 of the marked up copy, we propose to add Regulation 2A to empower the Commissioner of Police to specify the person to whom and the place at which a fixed penalty or additional penalty may be paid, and how a fixed penalty or additional penalty may be paid under Section 11A bracket 1. Any questions? If not, please proceed. Clause 44, page 88 of the markup copy, Regulation 3 amended. Forms 1 and 2 will be repealed, and it will be substituted with the words fixed penalty notice and demand notice. And that is why we will be changing some of the wordings, and we will add 3G, which says through any other payment method specified by the Commissioner of Police under Regulation 2A in the notice, to provide more means of payment. Any questions? If not, please proceed. Now, we also propose to amend 3(2) to clarify that if the payment is made through the counter, then the notice number or the electronic payment number specified in the notice must be provided for, along with the printed copy of the notice. Any questions? If not, please proceed. Clause 45 of the bill. We propose to add Regulation 3A, which specifies that the certificate of service must be in the form of Form 2A or 2B in Schedule 1. Any questions? If not, please proceed. Clause 46 is to amend Regulation 4. We propose to change the words schedule to Schedule 1. Any questions? If not, please proceed. Clause 47 of the bill. We propose to amend Regulation 5 and to change the word schedule to Schedule 1 again. Mr. Dennis Lang. Thank you, Chairman. I would like to ask about 3(1)(f). There is a punctuation at the end of the sentence. (3)(1)(f). There is a circle with a stroke across it. Legal advisor, please. Thank you, Chairman. Thank you, Mr. Leung, for the question. The punctuation in the marked up copy is put there by the Legal Service Division to make it clear for members to see which part has been amended. Under C(1)(f), this sign here means that the part is proposed to be cancelled and a semicolon or will be added there. So there's no special meaning to it. Correct? Yes. Okay. Because it is not mentioned. Because usually when they want to repeal some part of the sentence, they would just cross it. But because we are repealing a punctuation, and it will not be clear enough if we just strike it with a line. Well, it was a full stop there, and we propose to repeal the full stop. Is that clear? If not, please proceed. Clause 48. That is page 90 of the marked up copy. We will prescribe Form 1 as the prescribed form and change schedule to Schedule 1. And we will add Form 2A, the certificate of posting of demand notice, And Form 2B, Certificate of Electronic Service of Demand Notice. Which page are we at? Page 121 of the marked up copy. We've come this far? Well, because we are repealing Forms 1 and 2.
(116, 117), something has been added. Yes, there's Form 2A, the certificate of posting of demand notice, and 2B, the electronic version. Questions? Right, please. Form 3. Certificate of identity, registered address, and non-payment of fixed penalty. We add registered e-contact means, and B. We add e-contact means. Yes, please. Any questions? No? Please carry on. Clause 49. 121. We add Schedule 2. Prescribed information, fixed penalty notice, and all the relevant information, and electronic fixed penalty notice. And this is in line with CAP 237. I don't propose to repeat them here, unless members have any questions. Any questions? Mr. Leung, Chairman. 0119, Form 3 through to 0120 G. There is a reference to the Commissioner intending to there is a discrepancy, some inconsistency there in Chinese version. There is no amendment, no textual amendment here. Are we sticking with this wording? Yes, and the word "" intention was amended. Mr. Chen, as we explained, the two Chinese terms are the same. It's just a textual amendment. As to whether we should make any textual amendments, it would depend on the ancillary amendment. Here, in para F, we would not specifically make any amendment there, so as not to lengthen the text. The meaning doesn't make any difference at all. So like I said a moment ago, we would make the amendment as we are making the amendment. Otherwise, if it carries the same meaning, we would not make any alteration there in the Chinese version. All right, clear? Please. Moving on now to Part 6. That's CAP 374. Any questions, legal advisor? Clause 50, page 127, page 4146 on the blue bill. Under CAP 374, we add two interpretations, SMS message and e-contact means. E-contact means is actually moved from the CAP 237. These include electronic mail address through which the person can be contacted, or a telephone number in the numbering plan through which a person can be contacted, and this should be a local number. Any questions? Clause 50, 0128, we propose to add 62A. After 62, we add 62 A, B, C, D. There are 7 different interpretations. Demand no driver concerned electronic message, electronic record, ETO, information system, and personal particulars. We need these interpretations to make this clearer. Any questions there? Please. Clause 52, 53, page 129, replacing section 63, we add 63A to G. 63 is deleted. We put in place 68 to 63G in replacement to rearrange the text, and we add the provisions regarding the serving of e-notice. Any questions? Please carry on. 63 will replace 63. If a vehicle has committed offense under 374, or if there is an offense on the road, the police officer would can require the details of the driver and the relationship with anyone with the relationship with the driver. And a demand must be made within 6 months and may be made orally or by notice in the specified form. Now, what if they refuse to make available the information? Is there any penalty, please, Ms. Cheng? The penalty is level 3, or $10,000, or imprisonment of 6 months. Thank you. Any questions? Please. 63A, Mr. Lai. What you do will extensive power. It covers anybody. What is there in the existing provision? Right. What is the existing provision like? Mr. Lai, which provision are you referring to? 63 is in existence, isn't it? And they delete 63 and put in place some new provisions there. 63.2 says that a demand may be made orally. Now, if we're talking about the driver who is liable, then that's another matter altogether. But what about the passerby? Does the passerby have the legal obligation to make available such information? Chairman, as you said earlier, failure to provide the information constitutes a criminal offense. So what does the existing section 63 say? Under the existing 63, number 1, where the driver is suspected of having committed an offense, or where, owing to the presence of the vehicle, any person, including the registered owner or the person suspected of being the driver, shall, on demand made within 6 months after the date of the offense, give to the police officer in the manner prescribed the driver of the vehicle and the driving license and so on. Well, this has been broadened under the existing ordinance, it does contain more specific information, like the driver or the owner of the vehicle. Here, you say any person, and this is really extensive, isn't it? By comparison with the existing provision, I'm sure that there is a bit of a discrepancy there. Do you agree with me? Mr. Lai said this is covering a broader range of people, and is it appropriate? Right, let's go into greater detail about it. Section 63, 2A and B. What is the difference between the two? Chairman, the way it is couched doesn't change the existing arrangement. We haven't extended the scope. Now, any person is in the original version. Now, the police officer can ask any person to make available the information. We're just breaking this up to make it clearer. Mr. Lai, well, the administration read out the existing 63. This covers the driver or the owner of the vehicle concerned. The owner is not here in the new version. Why do you cross out the owner? If you refer to the owner, I understand if the driver has done a runner and you really pursued the owner as to whether he has loaned the car to anybody. It seems to me that this is couched in broader terms. Now, what is the purpose of taking out owners? Chairman, the new version 63(2)(a)(2) provides that if the person is not the driver concerned, it means they can include the registered owner of the vehicle. If the person is not the driver concerned, the person particulars of the driver concerned, the relationship of the person to the driver, it can be the wife of the driver, can it? Mr. Chen, Chairman, let me attempt to address Mr. Lai's question. When we conduct the investigation into a vehicle, we would issue the Form 63 to the driver, that the driver may have, or the owner may have let somebody else drive the vehicle, or he may have lent the vehicle to a friend who would then lend the vehicle to another person. So we would be able to cover the layers of borrowing or lending. In actual situation, that kind of scenarios do happen. If you specify driver and owners, there may be some loopholes for people to exploit.
Chairman, what the police's representatives said was correct, but you use this word anyone here. It means that you can ask someone who is or is not at the scene. As long as you believe that person has knows what happened and can provide relevant information. As there are too many circumstances under which that can happen, that is why you do not specify the types of person that could be demanded to provide information. But the scope is too broad here. If you ask someone who is not involved in the incident at all, they would not be able to answer your question or provide you with information. If they cannot do so, then they will be violating the law. Shouldn't you go back and rethink about the presentation of the clause? Can't you just ask someone who is involved or concerned? Mr. Chan, thank you. For traffic investigation, when passengers, pedestrians are involved, we will not be issuing a 63 notice or Section 63 notice. We ask the person to come to the police station for making a statement. We will not be issuing Section 63 notice to persons who are not driving the vehicle or owning the vehicle. Section 63 notice only involves persons who manage the vehicles. When we want to ask pedestrians for information, for example, we will be doing so in other ways. Well, because there is not such an regulations for the issuance of Section 63 notice, I believe that was your internal practice. You mentioned that you will issue a notice, but for 3B2 and 1, it says that the demand may be made orally. So in practice, the scope of the laws is broader than what the superintendent just mentioned. There is limitations to the provisions, that is, the circumstances under bracket 2A and B. Ms. Chang, thank you. Regarding demand to be made orally, for 63 bracket 2, it is mentioned that the demand may be made orally or the notice may be served face-to-face or electronically. So we are not changing the ways of doing things currently. Mr. Lai was talking about the driver and the registered owner of a vehicle. But then here it says anyone, and Mr. Lai thinks that the scope of anyone is too broad. For investigation of a traffic accident, the driver and someone who is not the driver are covered, which means that anyone or everyone is covered. The administration may take your time. Mr. Lai is concerned about the scope of the persons covered. Mr. Dennis Lang, please. Thank you. Chairman, I would like to ask about Section 63, bracket 2. Under bracket 2, there is a bracket 4 about personal particulars, including the name, the address, e-contact means, and the number of the driver's license. Do we restrict the kind of address that they may provide? Because the person may be giving us the office or residential address. Shouldn't we specify the kind of address that they should provide? Because one may be providing the address of someone else, and that would not be a personal particular. An office address would not be a personal particular, for example. Should we not specify it to smoothen the law enforcement process? Chairman, we've made reference to the existing legislations before we use the word address. As for the types of address to be provided, perhaps I will invite the police to supplement. Mr. Chang Xiuming, please. After issuing Section 63 notice, the register owner will fill out the notice. For the verification of the personal particulars, well, it's very difficult. We will be issuing another letter to the offending driver according to the information filled out in Section 63 notice. If the driver responds, then it means that the particulars on the 63 notice is true. If the driver does not respond to us, then it means that we have to reach out to the registered owner again. It could be the case that the driver involved has moved to someone else or somewhere else because so we have to rely on the information filled out by the owner on the Section 63 notice. If the address is correct, then we will be issuing the summons. If not, then we will have to go to the owner again. We've always been filling out the address. Mr. Dennis Lang, thank you. I understand that this is the existing practice, but I think that the administration should look at the ways that they do things in order to smoothen their enforcement. When we want to renew our vehicle license and driver's license, we have to inform the transport department when we change our address, for example. And this is to facilitate their operation. According to what the superintendent just said, you have to reach out to the vehicle owner again if you cannot get hold of the offending driver. I don't think that this is the effective way of doing things. We'll follow up on that. Mr. Lai Tong Kwok. Mr. Tony Chair, please. Thank you, Chairman. I agree with what Mr. Lai Tong Kwok just said about the amendment to the 63 notice. I think that the scope of anyone is too broad, too. Because in the original provisions, after anyone, there's a bracket, and it says vehicle owner and driver. Is the legislative intent clear enough? In the original Section 63 bracket 2 bracket 3, it says a demand under subsection 1. But in the proposed amended section 63 bracket 2, it says a police officer may demand a person to provide. And after that, in bracket 3, subsection 1 is being referred to here again. So there is a certain scope. So we have to know if the scope is broader than before the amendment. I think that this is the case. Ms. Chang, please. Thank you, Chairman. Under existing 63 bracket 1, it says anyone bracket driver of the vehicle at the time of the alleged offense or registered owner. The driver of the vehicle can cover anyone apart from the owner, so we're not extending or broadening the scope of coverage. Can we ask the legal advisor to give us some advice? Thank you, Chairman. In the existing provisions, the content in the bracket, that is the person suspected of being the driver of the vehicle and registered owner, is deleted. In the existing legislation, it says any person, including both the registered owner and the person suspected of being the driver of the vehicle, which means anyone. It seems that the target is anyone in both of the versions. So the scope of the provisions before and after amendment is the same. That's the point of view of the legal advisor. Mr. Tony Che, would you like to follow up on it? I take the view of the professional. But it seems to me that in the existing provisions, they have limited the scope of the word any person by including a registered owner and person suspected of being the driver of the vehicle in the bracket after the word any person. But if you just include the word any person or a person, it means that a person who is or is not at the scene would be covered or included. Just now, the administration said that they have the power to ask anyone to provide information. And they can choose which provisions to invoke as a law enforcement officer. We are worried if the scope will be too broad, but if the professional legal advisor does not think that this is the case, then I would not have anything to follow up. Mr. Lai Tong Kok. Thank you. I would like to follow up on Mr. Dennis Lang's question regarding address. The Transport Department has the personal particulars of holder of vehicle license and driver's license, vehicle owners, including their address, residential address, or any kind of address. So as long as the Transport Department has the vehicle license or driver's license number of the offending driver, then it means that they have the identity card number of the suspected driver. Can they ask the licensing office for the details? If I remember correctly, anyone has to inform their transport department of their change of address within 3 months. So I think that the most accurate way to obtain the address of the suspecting drivers is not to ask for that from the vehicle owner, because the vehicle owner would also have to ask the suspecting driver of their address and then inform the relevant address to the police. I think that this is too indirect of a way to ask for an address. Let's follow up on the previous questions regarding the scope of the word a person or any person. Mr. Chan Siu-ming.
咁其實我哋
Chairman, when we received the reply to Form 63, it would be complicated, however you do it. If we just get the name and then they get hold of the address from somewhere else, it would certainly create additional workload. It would impose a heavy burden on the computer system. The simplest way is to give the name of the driver and also the contact information. As to whether this is the most updated information, they may not tell you where they live. If a registered driver or owner, if we identify the discrepancy in the address, like the member said, we would take out prosecution and we will follow up on this. The existing way of doing things is the most ideal way for all departments concerned. Right? Some members feel that this is a broadening out of the scope, and the legal advisor already said that the driver or someone who is suspected of being the driver mean any person, according to the legal advisor. Does member or do members accept this? Mr. Lai Chung-kwok? Well, for the existing provisions or the future provisions, well, I think this is a broadening out of the scope because the relevant person is in contravention of the criminal offense and there is a penalty. If the police have the reason to ask for the information of the driver, it is well justified. But if you use any person, we brush aside all the information in the bracket, it would be very broad. Now, certainly you would be able to ask for the information under the law. But if failure to do so constitutes a criminal offense, then there would be problems. Would the police instigate prosecution is another matter altogether, but from the way this is couched, it seems to me that you should reconsider or have a bit of a rethink to narrow down the scope of the provision. And I hope that the administration would have a rethink on this. Mr. Tony J. Chairman, the administration said that currently things are more convenient for them and they can ask for the relevant person for the information. And I hope that they would consider this. We emphasize smart operation. The administration must have the information in the files. Why do you still insist on me supplementing the information? If I change address, some departments would still ask for the information. Now we are moving forward. To a certain extent, you are sticking with the existing method without really making things convenient to the public. You do have the information. You said it would be creating a burden for you to search the information. And it would equally be a burden to me. And if I need to supplement the information in writing, you still have to wait for the information to come through. Why don't you make things more convenient? Well, we did raise this on day one. We said that the administration should apply all the information to all the departments. Now, we hope that the administration would have a rethink on this provision. Members feel that this is broader than it used to be. Can you do something about it? And let's hear from Mr. Dennis Leung. And then there's about time for us to wrap it up. Mr. Leung, Chairman, on Mr. Lai's point about any person, I don't see any particular problem with that myself. In the original version, any person, if you add the information in the bracket to make it more specific, or like the legal advisor said, this is not restricted to these people. Now, basically, any person is really broad. In many pieces of legislation in Hong Kong, any person is used. If you narrow this down, it might present enforcement difficulties. Like if you say that the person liable, how can you prove that this is the person liable? And if he's not the person liable, you have to seek further information. This may be outside the remit of the law. And I heard from the DOJ the existing provision is more easily comprehensible, but the way you break it down makes it even better, even more comprehensible. Whether the person is involved in the offense would depend on whether he knowingly withholds the information. If we do not deal with it like this, then you may not be able to identify the person liable, and you cannot do anything under the law. Thank you. Any response from the administration, Mr. Mack? DS? Thank you, Chairman. Like my colleague said earlier on, and also I heard the views from the legal advisor and Mr. Leung. Now, I share their views. Basically, we are talking about any person. And in the bracket, it refers to the kind of person that we are talking about, and this is necessary in terms of law enforcement. But in any case, we would discuss among ourselves to see whether we need to have any amendments. But our view is that we are referring to any person, and here we're just breaking this down in greater detail. Now, the member asked whether we would make it convenient. We should not ask people to change the address department by department. In fact, the TD and the police would have regard to the views of the audio, and if there are any changes, we would try to make it convenient for the members of the public. There are 5 minutes left. Mr. Frankie Yick, Chairman, on this particular question, I'd like to state my position. If the owner can, in compliance with the police request, provides the name of the driver, then it's okay. But if he says that he doesn't know, unless you have your car stolen, you should be able to know who is driving your vehicle. There should be some sense of responsibility. Like the unlicensed carriage of passengers, there is a bit of a loophole, and there is a penalty of $3,000. Mr. Mack? Well, Ms. Cheng already said that the maximum penalty is there not $3,000, but generally speaking, the court would hand down a $3,000 fine. At the Special Finance Committee, there was a reference to this. We are reviewing the legislation to step up the carriage of passengers without a license. And Section 63, we are considering whether there is a need for amendments, and we are prepared to consult the the panel in this regard. Yes, there would be more chance to have a go at this. Now we have 5 minutes left. Either we go forward or we go ahead or we stop here. All right, you're tired? All right then. The next meeting is scheduled for May the 6th at 10:45 a.m. All right, please block out your diary for this. At this rate, I think we should be able to get this out of the way in one more meeting. There is going to be CSA from the administration. All right, that's it for today. Date of next meeting, May the 6th, 10:45 a.m. Thank you very much.